In the world of trademarks, it's really important to understand the different aspects of the registration process. It's crucial for all businesses of all sizes, especially small, medium enterprises. One essential element in the process is the filing basis. Today, we focus on guiding brand owners through the complexities of the 1A or in-use filing basis for trademark applications at the United States Patent and Trademark Office. The concept of a filing basis in trademark applications. In trademark applications, a filing basis refers to the grounds upon which an applicant files their trademark or service mark application. Depending on your situation and the nature of your business, the United States Patent and Trademark Office, through the Trademark Electronic Application System, allows for multiple filing bases in the same application, with each filing basis aligning with different sections of the Trademark Act. And today we'll focus on the 1A filing basis. The 1A filing basis, or the use-based application, is applicable when the mark you intended to register is already in use across state lines, U.S. territories, or between the U.S. and a foreign country. The use in commerce refers to the legal commerce that the U.S. Congress can regulate. The term commerce here sounds more serious than it actually is, but it's also not as simple as you selling baseball cards to your cousin across the state line. To successfully apply the 1A filing basis, the USPTO requires a verified statement of actual use and a specimen that is a tangible example of the mark's use in the course of business. Examples could range from product packaging to a screenshot of a website where the mark is clearly visible. Now, what's the difference between actual use and intent to use applications? Those are usually 1A, 1B, the most common types of application filing basis at the USPTO. The distinction is actually pretty clear-cut. The 1A in-use application and a 1A, 1B intent-to-use application, the difference is if you're actually using your mark commercially, then a 1A application is the route to take. On the other hand, if you have a genuine intention to use your mark in the future, then a 1B application is the way to go. It's important to note that if you fall into the latter category, your application will be used on an intent-to-use basis. It's also worth mentioning that in some cases, you may be able to claim a priority filing date based on a foreign country's application or foreign country registration. This can be incredibly beneficial as it provides you with a significant advantage when it comes to securing your trademark through an earlier foreign filing. As per the Trademark Act, Section 44D, foreign application basis, is if you filed a foreign application within 6 months before your U.S. application, you can claim the earlier foreign filing date as your U.S. application filing date. But remember, to claim a priority claim through the foreign application system, application must be for the same mark and the same goods or services as identified in the U.S. application. Now your application has been filed. It's at the USPTO. What's going to happen next? This is where we discuss the role of the examining attorney and overcoming potential office actions. Post-submission, your trademark application is assigned a serial number and reviewed by an examining attorney. At the USPTO, the examiner reviews the application to ensure it complies with all applicable rules and statutes and approves it for publication in the official gazette. If any issues are identified that could prevent the mark's registration, the examining attorney will issue an office action outlining these matters. An office action is an official document detailing your application's procedural or substantive issues. Responding to the office actions promptly and comprehensively is crucial to moving your application towards registration. I hope I was able to clarify a little bit what a 1A filing base is. If you have any questions regarding your trademark application or any other brand enforcement questions, please feel free to reach out at 773-234-1139 or go to www.drishtilaw.com. Book a consultation. I'll be happy to take your call. As always, this is Sahil Malhotra. Thanks for watching.